Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode, episode 25, we're going to talk about community property in trust and how you can preserve some of the benefits of community property, especially tax benefits, even if you make a transfer to an irrevocable trust, which would technically, in a lot of states, terminate community property status. We'll look in greater detail a little bit at a private letter ruling that blessed certain techniques that have to be followed in order to preserve this treatment. As always, this presentation is not intended to serve as legal or tax advice, so please consult with an attorney or tax advisor if you wish to implement any of these strategies. So, it's hard for me to do the concept of community property justice here, but in a handful of states, they have community property laws, which essentially treat property acquired during marriage, other than by gift or inheritance, as being owned one half by each spouse, regardless of how that property is titled. Now, in order to have community property, you typically have to live as a married couple in a community property state. However, once you've lived there, if you move to another state, the property that was community property in the prior state will still be community property in the new state, even if the new state does not have community property laws. Now, some states, like Alaska and Tennessee, do allow for elective community property through a trust, even if a married couple does not live there, as long as there's a trustee in those states, which at least performs some administrative tasks with respect to the trust, things like preparing accounting, tax returns, things of that nature. Now, one of the biggest tax benefits of community property is the double step up in income tax basis. Now, what I mean is that in a typical co-ownership situation between spouses, each spouse would have one half of the property, like in joint tenancy or tenancy by the entirety, but only the one half interest owned by a deceased spouse would get a step up in basis. So the surviving spouse's interest would not be touched. It would still keep the old cost basis. However, in the case of a community property, the one half interest that is deemed to be owned by the surviving spouse would also get a step up at the death of the first spouse under Code Section 1014b6. And the ticket to entry is that at least one half of the value of the community property has to be included in the gross estate of the first spouse to die. So because of this double step up in basis, it's a huge benefit because the surviving spouse could turn around and sell the entire property and not have to pay income tax gain on any growth in value that occurred during the life of both spouses. Now, there was a recent private letter ruling that illustrated how property could be transferred in trust and retain community property status. Now, spouses often transfer community property to a revocable or an irrevocable trust. In our last episode 24, we talked briefly about revocable trusts, and it can be important to fund those with community property if you're in a community property state. And you don't lose the tax benefits then. But when it comes to an irrevocable trust, if not done correctly, the tax benefit, especially the double step up in tax basis, could be lost. But in this case, with an irrevocable trust, this letter ruling illustrated that these benefits could be retained as long as at least one half of the trust is included in the gross estate of the first spouse to die, and as long as the trust terms preserve community property treatment. Now, this letter ruling essentially mixed a multitude of concepts. One was a community property trust, potentially. The other was a domestic asset protection trust. And the other could have been an intentionally incomplete grantor, non-grantor trust, which is designed to allow you to escape state income taxation if you live in a high tax state and want to use the lower income tax rates or lack of income tax rates in another state. Now, that concept aside, one of the key issues in this ruling that the IRS found was that state law treatment of the trust preserved the community property status. So that was kind of the first ticket to entry. Even though the spouses didn't own the property anymore, the way that the trust was set up and the terms of the trust made sure that the community property treatment was preserved. Another thing that helped is that each spouse retained a power over one half of the trust under both Code Sections 2036 and 2038. They did that both by retaining a beneficial interest and a power to appoint the trust assets. And importantly, with that power to appoint, it was done in a way that kept them from being treated as having made a completed gift during life to other trust beneficiaries, because if there had been a completed gift, the community property status would have terminated and there would be no more double step up in income tax basis. Now, I won't get into the weeds on this because the letter ruling walked through some very complex facts under which there was a power of appointment committee, which was composed of the spouses here plus other trust beneficiaries, and this could allow the committee to appoint assets back to the spouses or to the members of the committee or to other trust beneficiaries. But essentially, the power of appointment prevented there from being a completed gift unless and until the spouses exercise that power in favor of other beneficiaries. So if that power was exercised, yes, it would have terminated the community property status, but as long as the power just existed, it prevented there from being a completed gift. And also, it was set up in a way where it wasn't a general power of appointment in the hands of the spouses because they didn't want this to be a grantor trust. Now, as to why, my theory, like I mentioned earlier, is that this was intended to be an incomplete non-grantor trust, possibly in Nevada, which would have been a ning, or maybe in Delaware, which would have been a ding, both of which have no income tax. So if you live somewhere like California, potentially you could set up this trust and avoid California income tax, although that treatment is very up in the air based on some recent cases in the last year or two. But that's a subject for another time. Thanks again, everybody, for listening to this episode of the 10th of an Hour. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening, and I look forward to seeing you in the next episode.